Okay, let's see. Dr. Petrova, are you there? Ah,
yes, I'm here. I'm here. Hello. Hello.
Okay, so Dr. Petrova's topic will be online surveillance and technology, from a European perspective, the risk of allocation and coordination. She is from the University of Sofia, Bulgaria, and she's joining us all the way from. Dr. Petrova, over to you. Thank you.
Thank you very much, but I have a little problem. I don't know how to show my slides. I can see this option screen sharing. Hello?
Do you see the button there that says share screen?
No, I can see it. That's why.
You can't see it. At the bottom, there should be participants, chat, and share screen. Maybe if you move your mouse a little bit, you'll see it.
Chat, and then?
And then you press share screen.
Okay.
And then you choose the one you want to share.
Okay, now.
Lovely.
Okay. So.
Ah, see? Yes, now you can just make it bigger.
Where is the begin? Yeah. You have it. Thanks so much.
Thank you, Dr. Petrova.
Thank you. Thank you. Good afternoon, everyone, and thanks so much for your introduction and your passion to stay until this late hour. My expertise is in the intersection of technology and criminal procedure, especially covered investigatory measures. Free forwards. Yes. Free forwards. Firstly, the term online surveillance in European criminal justice systems could refer to a measure or a criminal sanction. However, you are focused on the criminal investigation and not on the sanctions as electronic tagging a criminal court can impose. Covered surveillance measures such as secret camera surveillance and use of the covered listening devices, which don't concern communications data, will not be also subjected in this presentation. Secondly, I'm going to use for a purpose of this presentation the term lawful hacking, as more associated with the different covered online investigation surveillance measures for digital investigations. And on the end, in European criminal justice systems, there are two models of the online interception of communications. First, procedural, according to the codes of criminal procedure of the European member states, and secondly, non-procedural. This model is designed for intelligence services provided in a separate law on protection against eavesdropping. This information can be used for intelligence services for intelligence purpose, but it's in principle, it's not admissible in criminal proceedings in the European member states at the trial stage. My presentation is going to deal with the first kind of online surveillance. I'm going to talk about the challenges to government hacking as security threat and its implications in criminal justice context. Before providing the insight about the conditions for intrusion on fundamental rights and investigatory powers of the lawful hacking in the underlying procedural structure in German and Italian criminal justice systems, I would like to explore what impact the advances in the digital technology have on the law enforcement frameworks and practices. This approach will offer insightful perspectives on how digital technology can be used to support digital investigations and to identify challenges in managing uncertainty in admissibility of the encrypted communications transmissions, and stored data as evidence at the stage of criminal procedure in the trial. Then I'm going to consider the debate about the extent to which the prosecutor has access to information stored in cloud storage services or encrypted communications. Moving on to discuss some technical requirements and warrants authorizing access conditions in terms of the allocation of risk for procedural fairness. Based on these considerations, I will provide a number of suggestions for future direction to support law enforcement authorities in fostering of collaborative relations necessary for advancing transnational digital investigations. The digital communication has transformed the European society by building networks and social contacts using digital technologies. You are becoming more efficient in learning, teaching, and researching, continuously moving forward, improving from the last, and hopefully learning from our mistakes. The net is a source of opportunities for innovation, collaboration, and excellence. It reflects both communication and engaging with the public on all levels. The net is now becoming the most basic form to communicate with each other, regardless of location and time or destination on a global scale. However, the usefulness has another side, the total resilience and dependency. The net could be also a threat to European security or constitute violations of criminal law. The digital environment is a source of complicated, fast-moving and continuously evolving threats on many levels, threatening either an actual individual or groups or of individuals similarly, as well as national or international security matters. It's vulnerable at any level and at any time. Offenders can commit online fraud or child sexual abuse wherever they are in the world. With the growing awareness on cybersecurity, you are increasingly confronted with the question what we should try to do. This presentation is being prepared to respond to some of the issues associated with this complex and interrelated security challenges. The transformation to the information age is marked by technological change and new capability. The modern intelligence and crime scene investigation is an extremely dynamic domain with data coming from multiple sources, from bugging and wiretapping to lawful hacking and using drones by the police and other law enforcement bodies. The different tools and measures shape the current surveillance landscape. For example, in terms of the Internet of Things devices, you could get information from CCTV, facial recognition, facial images, national database, roadside fingerprinting, body-worn video cameras, smart devices, etc. The transformation of this data in evidence is a challenging process which requires interdisciplinary knowledge and skills such as understanding the technology, forensic aspects of architecture, storage devices, etc., and understanding cybersecurity, data protection, intrusion, hacking. Law enforcement officers need to have a baseline understanding that's cross-sectoral in the law and in the technology. The traditional telecommunications, but what does mean actually lawful hacking? The traditional telecommunication surveillance is ineffective nowadays since most of the communications is end-to-end encrypted. Law enforcement authorities collect the data before the encryption is performed. In order to achieve this, software is installed on the sender's device to intercept the information in its raw form before it's encrypted and sent to the receiver. This software could be also used for the access and search of the local data on the devices of an individual. Online surveillance, unlike traditional surveillance, allows to directly tap into ongoing communications, which the use of spy hacking software on the PC, laptop, smartphone, which allows to bypass an end-to-end encryption during WhatsApp messages, for example. And here is the further example with the online search of computers. The further example is here. That's the example for online search of computers. As emerging technologies have increased surveillance capacity, you are seeking for ways in which their effectiveness and legitimacy may be strengthened through an adequate legal framework and ethical standards. Addressing this issue, you try to answer the following questions. What impact the advances in the digital technology have on the surveillance, law enforcement frameworks and practices? How police and prosecution try to detect traces of activity and files on machines and gain access to encrypted communications data? And within this issue, there are two key subthemes, the taxonomy of the lawful hacking practices and the software used by law enforcement authorities. Building on this, the capabilities on the tools could be matched with the different kinds of lawful hacking practices and identify new ways to gain access to information stored in clouds or to communications data over encryption technologies when there is legal authorization. And the last question, how is law enforcement cooperation in criminal matters affected by different legal frameworks in Italy and Germany? The general European framework on these issues is the Convention of Cybercrime. It provides criminal procedural law powers necessary for the investigation and prosecution of such offenses, as well as other offenses committed by means of a computer system or evidence in relation to which is in digital form. Articles 14 and sec of the Convention set out procedural law such as conditions and safeguards, expanded preservation of stored computer data, expanded preservation and disclosure of traffic data, production order, search and seize of stored computer data, real-time collection of traffic data, and interception of stored data. You start with a comparative analysis. For intrusions on the fundamental rights and investigatory powers of the lawful hacking underlying procedural structure of the German and Italian criminal justice systems, it aims to identify potential obstacles to successfully establishing effective cooperative framework, such as power to issue warrants to law enforcement officers and grounds on which warrants may be issued. The both European countries, Germany and Italy, has implemented the convention in their domestic law. In Germany, as in Italy, efforts to counter cyber threats and detect cyber crimes make use of both intelligence and criminal investigation. However, as they represent two different criminal systems, the inquisitorial and the hybrid system in Europe, the extent to which certain investigatory powers may be used to interfere with privacy differs across interception criteria and procedural safeguards. The both countries have adopted law on lawful hacking in 2017, but in different extent. Sections 2 and 10 of the Constitution of Germany provide a constitutional framework for investigatory powers to obtain communications data by guaranteeing the protection of privacy and personal data and in information technology systems is used for neutralizing future threats to public security, such international terrorism provided in Section 5, 49, and 51 of the Federal Criminal Police Act. Section 51 of the Federal Criminal Police Act provides the legal basis for interception by police for monitoring of one or more information technology systems, while Section 49 sets out the provisions for online search. That's the verdeckte Eingriff in informationstechnische Systeme. Police officers may intervene in a computer system and obtain stored data if there is a justified assumption that there is a threat to life or freedom of an individual or a group of persons, or the interest of because of the interest of the national security. The interception of communications data warrant could be allowed if it's needed. Further restriction concerns the technical implementation of that countermeasure. There are enough guarantees in place that stored data will not be obtained. Online interception of communications data was introduced in 2017 for detecting crimes. A targeted interception warrant based on concrete suspicion of a committed crime has been issued under Chapter 1 of Part 8 Code of the Criminal Procedure. Article 100A at SEC German Criminal Code of Procedure set out 3 different legal institutes based on the seriousness of the offenses that first of all, surveillance of communications, of electronic communications, namely interceptions, interception and recording of communications. That's the name of the online Telekommunikationsüberwachung in accordance of Article of 101 sentence 2 German Code of Criminal Procedure, surveillance of telecommunications, traffic data, and online search of computers. Moreover, the German Code of Criminal Procedure provides provisions of the compulsory cooperation of service providers in the course of criminal investigations. All of these targeted surveillance measures require a concrete suspicion of a committed crime. Access to stored to traffic data and to metadata have different interception criteria, since access to traffic data, IP address, telephone number and time and location, etc., have been understood as a weaker intrusion to the right to private life in comparison with access to the content of the messages, which touches upon the core of the right to confidential messages as protected by the Section 2 of the German Constitution. The threshold for the stored data is much higher in comparison with the interception of communications data, given the level of invasion to privacy. Besides these targeted measures, the German government is currently considering the adoption of legislation concerning not targeted strategic intelligence legislation for domestic intelligence operations. The German intelligence services would be able to view users' communications and data without the need to request internet service providers or third-party technicians to decrypt it. The measures can be carried out only with the consent of G10 Commission in Bundestag, the German parliament. Thus, these amendments will provide a clear basis for investigation powers already in use by this police service, as in 2014 was established a new department in the Federal Police of Germany. the department was designed to extend the internet surveillance capabilities at the federal stage. Italian constitution doesn't expressly recognize the right of privacy. However, the rules concerning online surveillance have to face at least two principles, with the principles contained in Articles 14, 15 of Italian constitution, which respectively foresee the right to home in the right to freedom and confidentiality of correspondence and of every other form of communication. In his decision, the Italian court the Italian Supreme Court excludes a potential conflict between the use of interception of electronic communications and Articles 14 and 15 of the Constitution, and considered the obtained evidence as admissible at the trial stage. Legislative Decree number 196 tries to provide a comprehensive regulation of the issues related to privacy. However, in this law, there is no specific regulation on online surveillance, but it provides only some clarification of few aspects related to this topic. In November 2017, the government has presented a draft of the legislative decree that foresees the introduction of the Italian Code of Criminal Procedure of the possibility to register face-to-face conversations using the malware installed on electronic devices and the limits of the use of these means. Hence, no specific regulation has been provided yet with regard to online search. Legislative Decree number 260 has set out new norms about the investigation of electronic data protected by encryption for targeted communications, a series of judgments and decisions of the Italian Supreme Court concerning the interception of the norms about interception of communications and obtaining of communications data led to the adoption of this decree. In fact, the use of malware, after being very discussed for a potential break of the above-mentioned constitutional principles, was the subject of the decision of the Supreme Court of Italy, that stated that the collection of face-to-face conversations in private places can be done thanks to malware when the investigations concern organized crime and terrorism. The norms, these norms determine the cases. Legislative Decree number 103 delegated the government to adopt a legislative decree on this matter, substantially accepting the Supreme Court's statement. The norms determine the cases under which substantive criteria and procedural safeguards such investigative tools is used as indicated at section 614 Italian Code of Criminal Procedure. Moreover, they regulate the procedures of authorization of the use of these tools. For example, the judicial decree which authorizes the use of captatory must specify the reasons why such investigative tools is to be used, and in some cases the places and time in relation of which is what this activation of the microphone must be indicated. In addition, at the end of the operation, the captatory must be deactivated in a way that it may not be suitable for further uses. The law provides that the data acquired outside the time and place limits, in the case in which time and place must be indicated in the judicial authorization decree, cannot be used in the process. As the online surveillance has become still more a multifaceted enterprise by police and intelligence services, in both European member states are established specialized special cybercrime centers and coordinating centers in cooperation with internet service providers and other security security authorities. As a mixed hybrid system, the Italian approach provides a more nuanced consensual basis for procedural fairness, while German doctrine and jurisdiction try to identify a systematic approach in the preservation of evidence. How important, I come to the next and last question, how important is the allocation of risk for procedural fairness? It is no secret that online surveillance as a covert investigative measures can undermine cybersecurity. What is less discussed are the prediction and transparency to technical standards, which are challenging in terms of allocation of risk in the law enforcement and mitigating risk of using encrypted evidence in criminal proceedings. The implications of European criminal policy point to educating the asymmetry currently favoring effectivity in criminal procedure. In addition, the risk is not only attached to the conditions by which encrypted data will be converted into digital evidence, but also to desired requirements of the production of digital evidence in the light of risk allocation theory. Therefore, there are different concerns that require more than one response. Related to this, I would like just to identify a couple, some challenges that encrypted data bring to criminal procedure and to explore how the criminal procedure can be seen as fair to all participants as well as to the public, as well if the utilization of data is not seen as fair. It can be subdivided into two specific issues. What are the best ways of utilizing communications, transmission and stored encrypted data in criminal proceedings, and how to mitigate risk and manage uncertainty in attractive fact-finding process, respectively how law enforcement authorities could obtain access to places such as cloud place where criminals have evidence, whilst also ensuring data protection for the individuals involved. First, the legal framework regulates many aspects such as privilege and guarantees to freedom of the lawyers and third parties, the use of the acquired materials in the process, the possibility to publish the acquired material, how to collect the collected evidences may be used, and in relation to which crimes and many other topics. However, as the process description of investigation methods are confidential, the codes of criminal procedure are rather vague in the matter of forensic guidelines. Criminal justice legislations in the European member states, in particularly German and Italian codes of criminal procedure, doesn't contain regulations in terms of technical tools which are used to perform investigation of electronic data protected by encryption. Moreover, law enforcement measures are special investigative methods special investigative methods are not public. It's not clear to what extent the prosecutor has access to information stored in clouds or encrypted information, respectively have to disclose this further in the criminal procedure. The lack of predictability and transparency about this generates a risk of using encrypted evidence in criminal proceedings. Article 8 of the European Convention of the Protection of Human Rights requires that any individual measure of surveillance has to comply with the strict conditions and procedures set out in domestic law. The legitimacy of the evidential basis is a key point in the discussion of the access to data encrypted by law enforcement. This is a problem for constitutional principles such as proportionality that seeks to strike the balance between individual privacy and public safety. Any encryption of communications data, by definition, is extremely intrusive as regards individual privacy and liberty. This means assessment of the effectiveness and efficiency of the tactics used and analysis in relation of necessity, proportionality, and subsidiarity. In principle, the transfer of data from police to the court is covered by the general provisions on evidence gathering and admissibility. Having outlined, and I would like outlined the relevant investigational powers, legislation in case law, specifically in terms of online surveillance, it demonstrated this presentation that the merge of the different approaches can be efficient between the European member states. The online surveillance can be of a high challenge even within the European Union to the due to different legal systems, offering insights into the conditions for intrusions on fundamental rights and investigatory powers of the lawful hacking and the underlying procedural structure in German and Italian criminal law justice systems could be helpful for providing of novel solutions to support law enforcement authorities in fostering of cooperative relations necessary for advancing transnational investigations. Furthermore, to make efficient use of online surveillance between the European member states, it's recommended to implement a universal investigative tool to ensure the same basis additionally to guidelines in regards to digital forensics while considering policies and legislations on European and transnational, international level. This would have a positive impact in the already existing relationships by improving trust, reliability, and efficiency, and the admission of evidence in a court of law. For future research purposes, it's recommended to distinguish between the use of online methods to investigate ordinary crimes and the use of hacking techniques to investigate cyber crimes carried out using a computer or crime that attacked a computer system. In Europe, the rules are fairly set, for example, how to conduct a murder investigation and obtain evidence that may be in the form of text messages or photos on someone's iPhone. On the other hand, the rules may still be unsettled in each European member state on how to use hacking techniques for conducting investigations on cybercrime, and what is the nature of the cooperation among the government investigators, the victims, and the communication service providers whose network may have been used in the course of the attack. With the two sentences on the end as a conclusion, with the emergence of AI technologies, the digital investigation in criminal cases enters a new era. The complexity of the ever-changing nature of crime, particularly in terms of digitalization, the risk allocation, and the ethical and legal challenges are enormous. Governments have been strengthening their prevention and crime scene investigation posture in light of the changing of the changing and evolving internal security environment. They are using conventional and emerging technologies in prevention and crime scene investigation domains. The politicians and police leadership are making sure police officers have the right powers and the right technology to do their job effectively. As the use of malware is regulated by the German and Italian law enforcement can be authorized to access covertly computer systems, but they differ across competences and procedures as well as techniques used in practice. The legislative intervention in Italy concerns only a part of the area of the potential use of this malware. While the online surveillance is regulated, the online search is not a subject of rule of law. This makes difficult the evidence sharing between the relevant law enforcement and the implication of different cooperation legal instruments. In making sure that you are in the best position to face the challenges in the future, it's important that you develop a shared understanding on the landscape of crime and a shared understanding of what works to deliver public value, including commitment to reach our communities, protecting the vulnerable people, contributing to the well-being of communities and individuals globally. Thank you.
Thank you very much, Dr. Petrova. I think a very insightful presentation. As much as we're talking about African cyber law, it is actually always very important to see what is happening with our counterparts overseas, you know. to see how they are developing their laws and the application of the law, not just developing conventions and laws that no one tests, but this is the actual application of the law. So a very dynamic presentation. Thank you for that. I see here there's a comment by Mr. Gumede. The German-Italian exposition has been very insightful, and you've given a clear analysis of surveillance concerns. Dr. Petrova, do you have any further remarks, if any, on whether you have a chance to investigate to some degree any areas of mutual concern and mutual interest with regards to Europe and Africa in the context of surveillance? Thank you, Dr. Petrova.
Thank you very much for this interesting question. Of course, that's the future. I would say that's the future, the cooperation between the European Union, the instruments implemented in the countries, European member states, and of course, the mutual cooperation with the countries from Africa, because that's because the cyber problems are globally posed, and there is no borders, there is no and you will need to find a base, find together a base for mutual cooperation in these issues.
Thank you, Dr. Petrova. Are there any further questions from the floor? I see Mr. Gumede says, thank you, Doc. Looks like he's happy with your answer. Are there any further questions for Dr. Petrova? Whilst we are on that, we are actually, it's 15 hours and 42 minutes, which means we're actually 3 minutes away from closure. We all know about Zoom fatigue and MS Team fatigue. So I don't want to keep everyone here because I want everyone back tomorrow. But we did say we were going to recap on the issues in this session. Just to start off, we started off with the concept of cryptography / cryptocurrency in Africa with Dr. Ngenda at the beginning. And then Ms. Musoni came with a very interesting presentation on jurisdiction and how jurisdiction affects cloud evidence. Then Ms. Narushka Bowen given us a exposition of the current South African legislative framework relating to cryptocurrency. And the last very interesting presentation on online surveillance in Europe with an emphasis on the Italian law as well as the German law by Dr. Aneta Petrova. I would propose, if there are no further questions for Dr. Petrova or any of the participants, that we close for the day. We have one more day in front of the PC, that is tomorrow. Just to recap the people who are going to be presenting tomorrow: Judge Chakwi will be presenting, Dr. Sebutladi from UNISA will also be presenting. We will also have Dr. Enrico Colendro from Research ICT. I'm looking forward to his presentation. A colleague of ours, Ms. Priya Chetty, and Dr. Lee Swales, as well as Dr. Caroline Nwabuze from Nigeria, and Mr. Yusuf Kalio from the National Cybersecurity Forum in Tanzania. I must just say, I find it so interesting, when we started this conference, everyone, was Mr. And I see now, when I look around, a lot of colleagues now are doctors and professors. So I just wanted to wish everyone a great one on that. We've come a very long way in this cyber law in Africa. And I propose that we adjourn for this afternoon, get back to your offices and do whatever you were supposed to do instead of being online. And and come back tomorrow fresh for the last session. It's been really great, and I appreciate everybody's participants today. Thank you very much, and goodbye.